are moving on to what we had promised a little bit earlier. East African economies have grown so rapidly in recent years that large brown owners are not only making substantial investments in their brands, but are willing to go to court to protect them. Joining me to understand how worthwhile it is for brand owners to enforce their rights is John Syekei, Head of Intellectual Property at Bowmans in Kenya. Thanks a lot for creating time to speak to us, John. First question that I would go with has to do with what we're seeing happening globally. The US and China are head-to-head in a war right now, and most of it, people are like, analysts all around are saying it's on the back of intellectual properties. Chinese companies, stealing rights from American companies, you could say so many of them, and that is one of the issues right now. How is this related to the case in Kenya or Africa?
Yeah, thank you very much for the question. You're right in saying that disputes around the world have increased in respect of enforcement of IP rights. And the big reason for that is that IP rights are extremely valuable and are the key drivers of most economies in the world, especially developed economies and developing economies. So in this particular case in Kenya, and similar to what you're saying about the US and China, a lot of big brand owners are coming into Kenya, Uganda, Tanzania, trying to acquire and maintain monopolies around their brands, and are seeking to enforce those rights through the court process in this market to ensure that infringers are kept at bay. So it's because it's a question of maintaining their monopolies and ensuring that consumers are aware of their brands.
John, now according to Moses Rogot, the Chief Executive Officer of National Commission for Science, Technology and Innovation, he stated back in 2016 that the IP regime in Kenya is not well developed. Do we have any update from that?
Well, I'm not. I think despite his views, I mean, I would think that the IP regime in Kenya is more developed than most African economies, countries. And the real reason for this is that, I mean, we are learning, but we are doing our best. The laws here are as good as what you find in a number of countries in Europe. It's just that in terms of the framework of enforcement, there are some hurdles that need to be passed, but there's a lot of goodwill from government. So at the end of the day, I would say that in our view, as Bowmans and the IP team here and the district team here, that we are confident that the regime and the laws in Kenya are in good order, and one can use them to enforce their rights.
John, there is much more need for more regulations and legislation on the intellectual property rights, but analysts do argue that our legislators don't necessarily understand IPs. Is this right, or if really is, what needs to be put better?
Yes, in terms of the understanding of IP rights, I do agree, and it is true that in some respect, some of these rights are difficult to grasp, and some of the rules and principles are difficult to grasp. But there's a lot of training going on at the judiciary level. International organizations such as the International Trademark Association are involved in trying to upskill the training of judges in parts of Africa, including East Africa. The practitioners in this market, for instance, in Kenya, are are involved in trying to train judges as well. And at the end of the day, the best way to develop and grow the understanding of this area is for brand owners to actually go to court and litigate, because once they go to court and litigate, then they create precedent in court, which can then be used to enforce similar rights in future.
All right. Thanks a lot for your time, John. That was very interesting speaking to you about the IP's landscape in East Africa. Now, moving